Legislation was introduced last week to require carriers and carriage service providers to keep a data set for up to 2 years. In fact, the data set's still to be determined by regulation, although the legislation says what can be included and what can't be included. ISPs will have the option to either comply immediately or create a data retention implementation plan, which is, if approved by the head of the department, can give them a step up to full compliance in due course.
And could we see the information used to target piracy?
Yes, the information will be effectively a honeypot for lots of different purposes. If you want to commence a civil claim for breach of copyright, then the information will be there and you can issue a subpoena to get it. If the federal police wish to prosecute you for a criminal offence under the Copyright Act, then they will have powers to access it as they could now by mandating that it be kept. But it will effectively challenge providers, because the amount of data that's being kept will be a honeypot for lots of purposes and require much higher levels of security and control than currently exist.
Well, just finally, what are the implications of the laws for ISPs, and is there anything they should be doing now?
The main implication is the cost of keeping the information. A lot of the sorts of categories that might be mandated in the regulation and are anticipated by the law are currently in logs which will be overwritten and are not kept for any extended purpose. So there could be new databases required, new systems for keeping and overwriting and enabling access to this information. The costs of that are a real issue for ISPs, and I think what they're doing now is talking to the government about how those costs might be met, and also what the precise data set that will be mandated in the regulation will be, and so they can work out, what the practicalities of meeting the requirement, what challenges that will present for them.